hearing an appeal, Farstad Supply against Enviroco Limited.
Yes, sorry. My Lords, last afternoon my Lord and the Chair said to me that probably my Lord's taken me across most of the ground for the case already, and on looking through I find that to be correct. I have, however, perhaps because of the way the discussion developed yesterday, a sort of almost miscellaneous little list of one or two points that my Lords may wish to hear from me on, and I propose simply to take those through. I apologise for the fact they are a little miscellaneous, that it's almost point 1, point 2, point 3, but with the benefit of that, as I hope, I may be able to conclude my submissions to my Lords reasonably promptly. The first matter I should call under their attention is the matter I was going to go to when 4 o'clock arrived yesterday. It's a point which may have, in view of the turn which the argument taken, less importance than otherwise it might have assumed. But I was going to call under theirs at Lord's attention the 28th tab in the bundle of authorities, which is an article taken from the most recent edition, the January 2010 edition of the Edinburgh Law Review, which is concerned with, in fact, this very case. And the points under which I wish to call my Lord's attention, which are on pages 365 and 366 of the bundle, are firstly on 365, at the end of the first paragraph under the subheading commentary.
Is that a submission of law?
Sorry?
Is it a submission of law, this?
Well, the purpose for which I wish to take it is perhaps something which trenches more on fact, but it's a matter which my Lords have canvassed already and seem to be reasonably prepared to accept, namely the common nature of these clauses across the industry, and the orthodox belief, evidently, though obviously it'll depend on what my Lords hold correctly construed these particular contracts are.
It's my fault. I haven't picked up the point you're trying to make, Mr. Howe.
Sorry.
We're looking at page 365,
365,
yeah.
The first paragraph of commentary where the author is discussing the orthodox view in the industry.
I mean,
that
of what doesn't seem to me. I'm sorry to interrupt, but really, it doesn't seem to me to be of any value at all. How can an academic, however distinguished, and I don't know him, without any reference to any particular source, give us anything that's useful at all from a statement like that?
Well, my Lords will take from it the value that they do. I see entirely the point my Lord Mance makes. The reason I call it under his attention is because, in fact, the particular place where this comes from, and the university and this particular individual runs one of the arrangements which are done in connection with the oil and gas industry in Aberdeen for looking at legal issues in the industry and discussing with the industry what people have and what their views are about that matters concerned. I hear what my Lord says, and I put it on that footing. What interests me,
actually, is looking back to 1940. We're 70 years on from there, and it's only in the very recent years that this whole problem has arisen as to how one deals with indemnity clauses and the right of relief and so on. That suggests to me that it's a fairly rare creature, or comparatively rare anyway, until we got into the business of North Sea oil and cross indemnities and charter parties and all the rest of it. I mean, we haven't had experience of this until quite recently. Am I right?
There are one or two cases which look at indemnities from earlier on, but they are few in number. And what's more, from what I could see, they tended to be ones where the indemnity is outside the relationship of the people who are seeking contribution from each other, i.e. the indemnity is one stage further down the line yet.
Yes.
My Lord is, I think, correct in what he says in connection with the kind of situation that presents itself to the court here, which first seems to have turned up in the North Sea oil context in cases like Piper Alpha, Diamond. A set of the cases have been put before my Lords in the bundle.
Yesterday of the accident, road accident at the junction and vans and all that kind of thing, one would never find this kind of problem in those cases, would one? mean, it's only where you have a comparatively sophisticated set of contractual arrangements which we find in these contexts that it's likely to come up.
It certainly hasn't turned up. And my Lord put to me yesterday that it was perhaps, the example I was figuring was one which was perhaps comparatively unlikely to arise in practice, notwithstanding the large numbers of accidents at traffic lights. And I see that, as a matter of probability, that's likely to be so. The reason I canvass and figure that example is because I submit that the interpretation of the statute has got to be capable of covering that case as well as ones which may occur the more commonly. There was a point...
The more common case would be two vans belonging to the same outfit, and then there couldn't be any question of contribution, but you would sort it out by contributory negligence. And I suppose that's a point you can make. That,
yes.
That's simply not available here, unfortunately.
Indeed.
Yeah.
The reason I didn't mention that yesterday because I had at one stage figured the case of the two buses employed by the same bus company, yes, but the answer was obviously contributory negligence, and it didn't serve to advance the argument terribly correctly, though it perhaps afforded a parallel which suggested if I can do it on contributory negligence, ought not I to be able to do it on some other basis in addition, where the chance is that they are not owned by the same company, and that is a point I take.
Well, I suppose footnotes 16 and 17 are of interest, just as a general guide as to what's going on in the real world.
Yes, well, as I indicated...
I suppose if judges can pontificate about what goes on in the industry without any evidence, there's no reason why academics should.
On the basis communist error, fake it lex, or leg it.
Although this writer seems to proceed on the basis that draftsmen use words like on indemnity and hold harmless as if they meant the same thing as a sort of belt and braces, whereas it's our duty to construe what they actually mean.
Yes, well, that raises the question which my Lord and I were canvassing yesterday, which is whether or not it is right to give these, or one should give these words separate and independent meanings as being meaning to cover other things, or whether it's just an example, again, of the kind of problem that the court is familiar with in commercial cases because of the way that commercial contracts get drafted, that there is frequently redundancy and duplication and so forth, and the court simply has to decide which of the two is appropriate in this case. If I may then turn to a second point, there was a point raised yesterday by my Lords with my learned friend about joint and several liability, and it would be my submission in common with my learned friend that the Grunwald and Hughes approach, howsoever burdened or unburdened it may be by reasoning, is now the recognised approach, and that the case of the common contribution to the common result gives rise to joint and several liability, and thence the basic right of relief provided for in the cases which my Lord saw cited yesterday.
What was the case?
Grunwald against Hughes, which was referred to yesterday by my learned friend, and I believe it was my Lord Roger in the course of a discussion. There was an issue too which I should wish to make clear what my position is in relation to, and that is subsection 3.2 and subsection 3.1 of this statute. This was in my submission a subsection 3.2 case and could only be so because only the defender was initially sued. It was the defender who brought in the third party, and no case against the third party is adopted by the pursuer. Subsection 3, subsection 1 is concerned with the situation where the pursuer sues more than two people seeking decrees solid and against both. And the law does not, of course, allow the mere fact of whether it's the pursuer suing two or more people to determine rights of contribution in the manner in which the respondents set forth in the 15th paragraph of our case.
Would it be a subsection 3.2 case if one action was brought in Scotland and the other person was sued in England?
If if the pursuer sues in England,
Just suppose if Enviroco was sued in Scotland and ASCO had been sued in England. It wouldn't come within one, would it?
no, it would not,
So it would be a
because
subsection 2 case, but ASCO would be held not liable in England,
and if,
on the hypothesis we take.
yes,
But you say, nonetheless, you'll be able to get compensation under section 3, subsection 2.
under section 3, subsection 2, I can look for contribution, but if it be the case that in the action, as aforesaid, refers back to the kind of action which is raised by two or more persons, by the pursuer against two or more persons in Scotland, that was Comex holder diving. Part of the issue about Comex holder was that it related back only to Scottish actions, so that the 3.1 and 3.2 issue depends upon the notion that the actions concerned are in Scotland.
And I'm not sure that's necessarily so, though. I mean, it's a reasonable hypothesis that that ASCO would be sued in England, given the choice of law clause and so on. And if the result of that action was, for the reasons that have been discussed, that the action failed, that would mean, really, it would indicate that one wouldn't be able to get relief under section 3.2, wouldn't it? Because the person had actually been sued and had been found not liable.
Where a person is actually sued, at least in Scottish action, and found not liable, then there is no question of contribution under section 3.2. My Lords have seen that in the bundle. I think it's page 249 in the bundle, says that if someone has been sued on the merits, been assoiled, found not liable, there can be no question of somebody else coming along and seeking contribution under section 3, subsection 2 later. That's undoubtedly correct. The question which I canvass...
in a Scottish action?
In a Scottish action.
Suppose it was in an English arbitration or in Timbuktu or something.
Well, the reason that I venture to suggest some degree of caution might have to be placed about that in terms of section 3, subsection 2 is that since Comex holder diving indicated that such action as aforesaid in section 3, subsection 2, relating back to section 3, subsection 1, was talking about decrees in relation to Scottish actions, the hypothesis of section 3, subsection 2 wouldn't arise.
Wait a minute, it would, because the action against Enviroco would be in Scotland. This is the hypothesis we're putting to you. Right? So Enviroco is found liable in such an action. That's a Scots action, let us assume.
Oh, right. I beg your pardon.
But we're supposing the situation where proceedings were, for one reason or another, brought in another jurisdiction against ASCO and failed.
By the pursuer?
By the same pursuer. And we're asking whether in that situation Enviroco would be entitled to claim proceedings, claim contribution from the other person.
I regret that the fault is mine, but I'm having difficulty following how this is arising. If the first action is raised, if Enviroco is sued in Scotland.
So suppose, I mean, actually it could easily arise in the present action where ASCO are commencing proceedings against Farstad in England, supposing Farstad counterclaimed for damages and failed. You've got two parallel sets of proceedings here. ASCO is party to each. You're claiming contribution against ASCO here. I just want to ask, therefore, what would the effect of the English decree between Farstad and ASCO be on Enviroco's contribution claim in Scotland against ASCO?
So far as I understand it, my Lord, it would have no effect at all. The other observation I should say... So section 3.2 would still apply? Section 2 would on the face of it apply. I hope my Lord is not under a misapprehension and was merely putting his case to me figured as an hypothetical for the purpose of testing it, because the case that my Lords have seen, and to which they made reference yesterday in England, is in fact the case as between Enviroco and Farstad, not
You're
ASCO.
quite right. I apologise. Yes, you're absolutely right. No, I apologise.
And I was concerned when my lord figured that to me that he was
No, I
perhaps under
apologise. You're quite
misapprehension.
right. My confusion. But suppose put it as a hypothetical.
Yes.
Yeah.
Well, that's the answer I give my lord on the hypothetical basis.
Well, despite the judgment in ASCO's favour in England, you could still say in Scotland that they were someone who, if sued, might also have been held liable.
Because you're judging it, you'll be judging as at the date at which the original action was raised in England. And so if COMEX holder diving means that you're not looking back at this because it's such an action as aforesaid, it wouldn't be operating under the statutory hypothesis. Therefore, one imagines that in the case my lord figures to me, one would be having to look to this as a matter of common law arrangements, because the Section 3.2 hypothesis doesn't arise.
In other words, you're saying that subsection 1 refers to a Scottish action, therefore, as aforesaid in 2 refers back to a Scottish action. Is that right?
Yes, my
That's
lord.
your argument.
That's my
And
position.
it wouldn't be...
That's the first step of the argument. The question is, what about the second step?
The second step of the argument, which my lord is figuring to me, is, right, if the statutory arrangements don't apply in this class of case, what does? Is there any form of relief available at all? And if so, what is it? Which is what I understand
I mean,
my lord
who,
Mans
if
to be asking me.
sued, might also have been held liable is a reference back to a postulated suit against the, in this case, ASCO in Scotland.
Yes.
Isn't it?
That's what you're saying.
Yes.
It seems to me to be some force in that, just reading the language.
But it wouldn't be res judicata, would it? Because the parties are different. I mean, Enviroco wasn't a party to the English action on the hypothesis we're proceeding. But nevertheless, the matter would have been tested in a litigation, and it may not be, as I say, res judicata and incompetent to raise the action, raise the proceedings, but it would be a pretty powerful answer to the claim, wouldn't it, that it had been tested and found found not to be a sound action in England.
One would certainly expect that it would be, shall I say, uphill, but it is, of course, by virtue of the fact that it is not res judicata, it's perfectly open that it may be that a Scottish court, on the basis of an argument differently presented, perhaps the evidence is slightly different, to form a different view.
Could a Scottish claimant pursue an action in England, lose it, and then bring a virtually or indeed identical claim in Scotland, or would the Scottish court not throw that out on the basis that the claimant had already chosen a different jurisdiction and lost?
Once one is into the realms of res judicata, then plainly one couldn't repeat it.
The other parties would be different.
That is, as I understand it, the case being figured to me, yes.
So there'd be no res judicator, there'd be no issue estoppel, and so there'd be nothing to stop you saying, the defender saying, well, if the third party had been sued in Scotland, the action would have succeeded. And the mere fact that the action in fact failed in England or in America would be nihil ad rem, perhaps, depending upon how broad the doctrine of, whether there's any doctrine of collateral estoppel. But absent that, it's difficult to see why that wouldn't be the position.
Well, with respect, my lord, one may have to go quite cautiously on the subject of the various estoppels that are available in Scotland as opposed to England.
I don't know anything about them, Scottish law at all, let alone the Scottish law of estoppel.
In particular, issue estoppel traditionally is said to be a subject which probably does not obtain in Scotland at all.
It must be. Enviroco, would not be disabled from taking the point, and it would, I suppose, depend on what the ground of decision was in the English case. If it depended on an assessment, a judgment on the facts, Enviroco might be able to come up with a different version of the facts and persuade a judge in Scotland that actually, looking at the fresh set of facts, a different decision would be appropriate. But we're, I think, envisaging a decision in England which is testing the issue as to whether or not the clause prevents the action being taken at all, whether the existence of an indemnity prevents the pursuer from claiming against ASCO. Now, if that's the ground of decision, then I suppose what one would say is that the English decision on that issue would be persuasive authority,
Yes.
and the Scots courts would be entitled to take a different view if there was a difference of law in Scotland which would justify that view.
Which is why I described the case as uphill.
Yes. Because you're not...
Especially since all the facts here will be governed, that question will be governed by English law.
Yes, as
And
to
the
what the
Charter
clause
certainly
meant.
constructed
Indeed,
it,
I mean, it's very difficult to see how that could be different. So the facts might be different, but on the issue we're talking about, it's an issue of law where, although not res judicata, it would effectively mean the end of the action.
Yeah. Yes, that would be so. Again, however, at the risk of running the risk of repeating myself, whether this would be following under the statutory provisions may be another question, given the issue about such action as aforesaid. Again, with my apologies for the somewhat miscellaneous approach that I'm now forced having to take, I believe that I indicated yesterday, and if I did, I apologise if I'm repeating myself, but couldn't be quite certain from my notes that I had. The case which is made in this case by Enviroco as against the third party is one which is made in delict alone, as can be seen from pages 91 to 93 in the bundle, and the references on page 90 to the guidelines. So it's not a case which faces the potential criticism voiced by my Lord Mance yesterday, that one might find oneself founding on the contract for one purpose and then trying to ignore it for a second.
Well, this is the claim by Enviroco against ASCO.
Yes, it is. It's a delictual claim.
The duty of care must derive in some way from the Charter Party. Generate
no,
the
no.
factual basis of it.
The,
Well, in a sentence, what is the case?
the case is that they failed to carry out certain operations which they ought to have carried out under the various guidelines to which reference is made, and which any charter and operator would, if reasonable...
Play charterer, though.
Yes.
So that's the first thing you'd have to aver.
Yes,
Maybe
I'd
the
have to
relationship
establish
with charter.
Yes,
and
it's-
then you'd have to aver the terms of the charter party.
Yeah.
You couldn't just aver the charter party without telling the court what the charter party was about.
Well,
Just in an ordinary common law action, could you?
well, if one is
It's
founded
rather
on
a
the charter...
far-fetched case to me altogether.
Yeah,
No,
if there are-
that's another question.
Well, that's a question which happily my lords don't have to trouble with.
Yeah.
There are others who may have to wrestle with that some other day. Secondly, in my submission, subsection 3, subsection 2 of the Act is in a way an alternative to subsection 1. Both can't coexist, as is evident by the if sued hypothesis of subsection 3, subsection 2. And it follows from that in my submission that the test for ability to obtain contribution in virtue of the second subsection is not strictly what would happen in an action which arose in the first, but would be one which, to borrow from the phrase from Lord Keith that gets quoted in a number of the other cases that my Lord saw yesterday, like Singer and so forth, whether in an action competently, relevantly and timelessly brought, the pursuer would, if sued, the third party would, if sued to judgment.
This means
be
if
found
sued,
liable.
does it, at the same time as the defendant in the first action?
Yes, the date for judging these matters, just to deal with that incidental point, is in Scotland. The date at which all this falls to be tested is the date at which the action was raised against him who seeks relief, in this case, Enviroco. The authority for that, my Lord will find if he's seeking it, because, again, I apologise if it was my misnoting, but I think matters got moved around slightly in the discussion when my learned friend was asked about this, is at page 122 in the bundle, in an opinion of the Inner House in the Dormer case, issued by Lord Ironbridge.
Sorry, I just can't hear you, Mr.
Oh, I beg your Lord's pardon. It's my fault. I'm dropping
where
my
in
voice.
that page?
Page 122.
I think you said that time was when the action was brought against Enviroco. Is that right?
Well, let's
Surely
see.
it's whether they could have been sued at any time after the accident.
And I think, yes, the time was immediately after the accident.
Yes.
That's
That's what this
One
case said.
can envisage surely a case of joint and several liabilities where the liabilities arose sequentially. Therefore, the first liability might be time barred before the second one, so that you could actually commence an action against the second tortfeasor after the claim against the first one had become time barred.
That is true in such a case. One could do that, though in that case presumably one's concern would be protected in any event by the timelessly element of the competently, timelessly and relevant subsumption that is canvassed in the cases. The issue that my Lord Mance is dealing with is down at the foot of 122, where the view is expressed that the reference to any other person who, if sued, is referring to any person whom the pursuer could have sued at any time after the accident, and who could, if the facts justified it, have been held liable in an action competently, relevantly, and timelessly
Sorry,
pursued.
where is that stated?
122.
That is, say, 6 lines from the foot of page 122.
We agree with this view, the view of the Lord Ordinary,
Yes.
as accepted by Lord de Verd, subject to
To
our
our
earlier
ordinary
qualification that in the ordinary case, the date or time to be considered is the date when the action was raised.
Where the 300 is.
They are really, I mean,
I always thought it was the second of those, because I suppose you have a case where there's a short time limit against the... How does the subsection 1, suppose the pursuer sues both, and at the start, when he starts his action, he's out of time against B, but in time against A, so his claim against B fails.
Yes.
Now, then what? You could subsection, you wouldn't be able to get contribution under subsection 1 in those circumstances, would you?
Well, you wouldn't get a decree because your case would
Right.
be held to have failed.
Well, why is it
That's
any
number
different
one.
under subsection 2?
Because the subsumption of subsection 2 for the purposes of contribution, assuming that they're both, as it were, the pursuer is going against the, we'll call him B, the pursuer is going after B and is time barred as against B. C, who is also sued, says, I want contribution against B. So C is also coming against under his rights of apportionment. Now, the fact that there is no decree available to the pursuer under 3.1 does not prevent the defender from saying, I'm entitled to pursue a claim and contribution. He could, after all, do it in a separate action subsequently, provided he didn't allow himself to get time barred on his right to relief independently. So in subsection 3, subsection 2 cases, where what you're interested in is Enviroco is sued and then says, I want to claim against ASCO, but at the date at which that happens, a claim against ASCO would be time barred, then the subsumption for section 3, subsection 2 of competently, timelessly and relevantly means that the fact that the pursuer would be time barred against ASCO does not stop Enviroco from seeking such rights as it may otherwise be entitled in law to obtain for
that's what
contribution.
Lord Hodge deals with this in paragraph 13 of his judgment. This is tab 4 in the appendix. And I think he makes the point that in Dormer, the division has not closed their minds in time. They've closed the door, as he puts it, on the correct time at which to test it. but it does appear to be common ground between the various judgments that what you've just said is right. That's the way the thing works.
The whole of the top of first half of page 122 is decided on that very basis.
Yes.
Yes.
In Dormer.
Yes.
So,
But there is a point, actually, which I thought we were discussing yesterday about the pursuer's whim, because one of the questions that came up was whether it would be open to a pursuer after the accident took place to say to one of the wrongdoers, well, don't worry, I'm not going to sue you, I'll give you a complete indemnity, here it is, and then divert his attention to the other one. And the general view seems to be that that's not something a pursuer can do. In other words, he can't cut off the right of party B to sue against C, to claim relief against C.
As it was a contractual time bar.
That's the idea. He can't, I mean, if the contract preceded the accident, then a different view would be taken. At least that's the argument against you.
Yes.
And that suggests that if you're looking at that issue, the relevant time is the date of the accident.
So if there was a contractual time bar, like Article 3, Rule 6 of the Hague Rules,
Yes.
then what?
it could be, on this line of reasoning, effectively sidesteps.
That can't be right. That simply can't be right, because that gives you an absolute, the whole of the claim against you is gone under the Hague Rules. And if the liability is under the Hague Rules, I just don't think, speaking myself, that could possibly be right. Indeed, I very much question whether this is right.
And that's assuming the contract preceded the accident.
Yes, as it was, suppose it's a
Yes.
contract. Suppose the charter party, which is subject to the Hague Rule.
Yes.
I suppose it's a cargo claim.
I was going to say, my lord,
You don't have
presuming
to
the
decide
cargo
it in
claim.
this case.
No, we don't. But I also thought, is it not? It's discussed in one of the English cases. It's not discussed in Wimpy.
Yes, it does.
Yes, I think it is, because Lord McCluskey was looking at Wimpy and reaching the view that he did in the outer house.
I take the point it isn't necessary to decide in this case, but it's quite an important point.
Yes.
And if I may observe, my lords, the Lord Ordinary was obviously right in what he said in this case about Dormer, because at 122 in the 3rd paragraph, the court notes the case where different time bar provisions applied to joint wrongdoers. You might require to make special provision for that when they've dealt with their general case about the date when the action was raised against the person who sought relief.
Speaking for myself, it appears to me that it's very, very odd to say that to read what on page 122 does into if sued, because if you test it as if it were a Section 3.1 case, I suppose this case had been a Section 3.1 case, then the ASCO, who is both, in that hypothesis, would be both a defender and a candidate for contribution, wouldn't be held liable because he would, or it would be entitled to the benefit of the time bar. Whether it was a contractual time bar, an Article 3, Rule 6 type time bar, or if it was a procedural time bar, a Limitation Act time bar, he'd be able to say, well, I have a defence because the pursuer didn't start his proceedings in time against me. And that would defeat the claim for contribution as between defenders. Now, if that's the position under subsection 1, speaking for myself, I don't see how it can be different under subsection 2.
Well, the argument is that subsection 1 doesn't actually deal with any situation except where they are found jointly and severally liable. It doesn't say that if one of them is found liable and the other not, there's no claim to contribution, and that you can't in that situation fall back on 3.2. But I agree with you that...
You can't literally fall back on 3.2. Where anyone has paid damages in which he's been found liable, who, if sued, might also, when he has been sued.
Yes.
Quite. So you would say, well, this is perfectly ridiculous. It's a hypothesis which has already been tested.
No, I see the argument. We might have a look at George Wimpy perhaps at some point.
Anyway, it's not...
I thought that George Wimpy was about what if sued meant in the English context. And I see it's not the same point, but it's the same expression.
That's true. It is.
Certainly, my lord won't find that case in the bundle, but he will see that in cases like, I believe it's Singer, there are cross-references to George Wimpey in the decisions of the
All of this
House.
is a little self-indulgent because the issue doesn't arise.
I agree, it's true.
Sounds to me as if we would be unwise to express
But it does,
views in the area.
it is relevant to the relationship between subsection 1 and subsection 2.
Yes.
And the hypothesis upon which subsection 2 is that the third party was sued in the first action.
The hypothesis is that he, had he been sued, might also have been held liable in such an action, whether my lord call it the first action or otherwise. And what the authorities have said is that one tests this saying, right, if we assume a case which is competently, relevantly and timelessly made so that the party seeking contribution under section 3.2 doesn't suffer from, as it's been put, the whim of the pursuer and the kind of things which, as my Lord Hope says, appear to be common ground between parties in this case, that certainly after the date of the accident there is nothing the pursuer can do, be it abandonment, pactum de non potendo, anything which will serve to cut down the rights to contribution of the defender. And the question, or one of the questions in this case, as I submit, is when is it that those rights of the defender become cast in stone so that the pursuer can't
How does
have
Article
any
3,
effect
Rule
on them?
6 work?
Right.
Because the third party can say, well, my liability was discharged for any claim in rising out of the damage to the goods, is discharged after 6 months, or whatever it is, a year.
Yes, but that is a case where, as far as I recall, Rule 6, there is simply a contractual time bar by force of the importation into the bills of lading or whatever of the Hague-Visby rules, and therefore it's a case which comes to be simply an operation of limitation or time bar, whatever phrase one wishes to use it, at least in the one and only case I can think of in the last 10 or 15 years in Scotland in which that rule has turned up. That's certainly been how it's been approached. And that would therefore, in my submission, come under the subsumption that has been applied in the Scottish courts to 3.2 cases of the word timelessly. One says the failure to sue timelessly cannot serve to prejudice the rights of contribution of the third party in a Section 3.2 case.
Why can't the Scottish court look on it in the same way as it would look on an exclusion clause? I mean, I think you accepted yesterday the contractual exclusion clause would be given effect to. And is this not pari passu with that? It's expressed in terms of a limitation of time, but in effect it's a kind of exclusion because it's saying you're excluded when the time has elapsed. Are they not really pari passu with each other?
My submission to my Lord about that is the fundamental, as it were, the fundamental reason that I'm standing here, because I have accepted, as my Lord says, and have accepted in the court below, even when I was told I shouldn't have done, that exclusion clauses would serve to, if it be the case that contract can operate here as a voluntary action before the accident to affect rights of contribution, which is, of course, my first and basic objection to this, as my Lords have heard. If that can happen, then I accept that a clause which excludes liability, by definition, must mean that they couldn't be held liable. And
that would be a defence on the merits, wouldn't it? Your Article 3, Rule 6 point would just be an example of a defence on the merits. Just like a limitation clause. Just like a limitation of quantum clause, damages clause.
Yeah, because my Lord will correct me if I misremember, the rule says that there is all liability is discharged if suit has not been brought within 1 year of date of discharge of the cargo. And therefore, that would be operating as a defence on the merits because it would be, as it were, a discharge enforced by the contract. It's not, in a way, it's not a time bar at all. It's a discharge of liability. But that's, I suspect there's probably English authority analysing whether it's a discharge or a time bar, but it wouldn't matter. For a time bar...
But it shows that you can't use the rather attractive phrase, the whim of the pursuer, too literally.
Well,
because you could say it was
yes.
the whim of the pursuer not to start your proceedings within, or bring your suit within the substantive time bar.
Well, indeed, my lord, we'll see. Is it
I mean, there's nothing about whim of the
bundle?
pursuer in the section.
No, there isn't.
It's a sort of gloss.
The whim of the pursuer is an incrustation of the authorities. But the phrase, the whim of the pursuer, started off, no doubt, as a rather nice phrase because of the circumstances in which first it appeared, to do with abandonments. But in truth, I submit it really means their voluntary action or inaction. It's something they could have got done if they wanted and either didn't or did, as the case may be. It's about voluntary action. Whim is just a rather nice, colourful phrase for it.
I mean, the real question is not whim or otherwise. The real question, insofar as it arises, is at what date do you judge the words "if sued"? I mean, if you take the date when the action's begun, then that gives you one result. If you took the date when the cause of action arose, that's another. But if you took the date when the cause of action arose, you'd still get Lord Hope's point that this might be regarded as analogous to a clause, an exclusion clause which bit from the start, because it's a discharge of liability clause. It effectively says we've got here, like an atom, it has a limited life.
But putting contractual limitation on one side, I don't know, can't remember whether the statutes dealing with limitation make express provision for claim for contribution.
The answer to that, my lord, is yes, they do.
Well, ordinarily it starts at the moment of the liability, doesn't it? Time begins to run. For the contribution claim, time only begins to run when you're held liable.
If it begins to run when you're held liable,
Possibly
that would
when
be
you're paid.
inconsistent. Seem to be inconsistent with any suggestion that time's already running against you because it started to run at the time of the original cause of action.
That may be right.
Remember, Mr. Howe, when it's the rights of relief, when do they?
It's
prescription, I presume.
Well, it was changed in 1984 from memory. It used to be limitation, and then it became prescription, and it prescribes 2 years after the date on which you were found liable from memory. It's 2 years.
2 years from the date you found liable.
Found liable from memory. I think it's section 8, subsection 4, maybe.
Then it'll be somewhere there.
It's round about the middle of the Act.
Yeah.
However, the submission which I am presenting to their lordships, and which I recognise their lordships will wish to test by reference to all these possibilities, including the discharge claim under Rule 3.6, is that in 3.2 cases, at least hitherto, the authority has been in our house. One deals on the subsumption of relevantly, timelessly, and competently raised actions. Now, I recognise that there is perhaps something of a curiosity in the implicit assumption, in particular about the relevantly word, given some of the discussion which passed between my Lord Roger and myself yesterday. Because if one is looking at the case of the contractually based offence, whether it's the exclusion clause, the indemnity clause defended on the frustra praetis basis, the discharge clause, perhaps of the variety that my Lords Manson and Clark figure with me in the last few minutes, in some respects the if relevantly pleaded hypothesis may start to break down, because the thesis may be that the whole point of the defence that's being canvassed is that the case is not, necessarily cannot be relevantly pleaded, so the hypothesis can't arise. It may be that one figures an attempt to get round that what relevantly means in this connection is that the case is devoid of technical pleading errors which might otherwise cause the case to be defeated, as opposed to one in which there is some substantive ground of law. causing dismissal. Because otherwise the kind of situation which my lords are figuring to me cannot arise, because the subsumption is that the case is to be relevant.
Sorry, I don't think I'm following Mr. Hyde.
When my Lord Keith originally put up the relevantly, competently and timelessly thesis, what one is contemplating is someone then who might be found liable if such an action were brought. The case that my Lord was putting to me yesterday, for example, with the indemnity and the frustra petis defence, would be that if that were right, a case by definition couldn't be relevantly brought. Therefore, Lord Keith's hypothesis could not operate unless one read relevantly as meaning a little like it says with competently and timelessly, without you making any mistakes that would put you out of court.
If you couldn't bring a relevant case, does that not just bring the answer?
Well,
I mean, you couldn't have been sued. I mean, the suer couldn't have sued them. That's all it means. There's no possibility of having a relevant action. It would fail. I mean, that's
yes. Well, that is what has been canvassed with me. Yes.
So I don't quite. That's why I'm not following the point you're making about if relevantly. I mean, if you assume that it couldn't be relevantly averred, then that simply means you could never have been sued.
I beg my Lord's pardon. I see the point he's putting to me, that sued, the relevantly qualifies the sued, so that if you don't, it's not a statutory assumption of the suing that's done. It is that you simply can't meet the contingency of being sued relevantly because there is no relevant case to make.
Yes, I mean, yes. I mean, it couldn't have been done. I mean, it's simply it couldn't happen.
I suppose Lord Keith was assuming when he used that phrase that you could make a relevant claim.
Yes.
I mean, I don't
course.
think
Well,
the issue in
that's-
that case was otherwise. He was just assuming that,
Yeah.
you got a relevant claim in theory, and in practice you put it into practice by making all the relevant averments, and it's a competent action and it's a timeless action.
Yeah, exactly.
But he's not dealing with the problem which arises where you couldn't possibly make a relevant claim at all.
No, well, in that field, it's fine.
Yes, I think it's all right.
Yes.
Well, I must say George Wimpey is quite interesting, at any rate, in the context of the English law, because the House of Lords rejected an argument advanced by Mr. Kenneth Diplock that Section 6(1)(c), which says any tortfeasor liable in respect of that damage may recover a contribution from any other tortfeasor who is or would, if sued, be liable in respect of the same damage. Mr. Diplock argued that it should be construed as if it read, if sued at the date when the cause of action on the part of the injured party arose, have been held liable. They rejected that on the basis that that's not what the Act says. To my mind, there's a lot to be said for their analysis, and it was a case in which there had been proceedings, and the defendant, the abusive third party, had been held not liable because the claim was time barred, because the plaintiff's claim was time barred, which is exactly the hypothesis we've been considering, and they reject that in clear terms. Now, that is not binding, of course, in this case, because we're construing a different statute, but it's a very similar statute.
It is similar, and one may
And indeed,
probably assume from the dates
the expression
that
if
the
sued
Scottish
might
is
have been
affected by
held
them.
liable has actually been construed as means if sued would have been held liable. I think so. It's
Yes.
really almost identical phrasing, language.
Yes, there is a comment made by Lord McCluskey in Dormer about the two concepts being rolled into the one in Section 3.2 and
So you'd
the
expect
might
them
have
to
been
be,
held
and,
liable.
and also if you step back and look at the policy of the thing, you'd expect them to be the same. And to my mind, well, they also made it quite clear that once you've been held not liable, that was it. You couldn't start a new action against somebody who'd been held in the primary action not to be liable. And again, to my mind, the sensible course would be to test it as at the date that the suit is brought in the first action, in order to protect the potential defendants so that they know whether their claim's time-barred against them. Otherwise, otherwise it's an absolutely endless. The third parties in a exposed to what may be very wrong.
He is exposed until the prescription period that my Lord Roger was discussing with me steps in, on the alternative that my Lord Clerk is now figuring, because he's exposed until whenever it be that the end of litigation number 1 comes to be, whenever that is, +2.
Right. Whereas this analysis does protect the third party, at any rate to the extent that the plaintiff's action, which is after all the basis of the on which the contribution is to be based, has got to be brought in time.
Yes, that's correct. And it's meant to protect also the contribution right, to assume that the contribution right can't be cut down by the failure of the pursuer to raise his action in time in the first place.
To my mind, that's more convincing than page 122.
On page 123, there's reference to Wimpey and the fact that the decision was reversed
Yes, he was in the
by the 1978 Act, and
Yes.
I'm not quite sure what point was being reversed there, but I think it's for that reason the Scottish courts have tended to feel that Wimpey was not something to which close attention needed to be paid. And there's a sort of feeling that we don't need to have trouble with Wimpey because the legislation's different and therefore it's not relevant.
It was said by Lord President Emsley, from memory, in Singer,
Yes.
that certain passages in the Scottish legislation reflected that in Wimpey. If my Lord will bear with me a second.
Yeah, but it's the last page.
Yes.
No similar problem arises in the Scots legislation.
Well, that's not Lord President Emsley. That's Dormer.
Yes,
I think.
right.
But Singer is
Is,
elsewhere in the bundle, isn't it? 19, tab 19.
yes. Page 249 in the bundle is
Yeah.
what I had in mind.
Well, it's of interest that in George Wimpey, Lord Reid was one of the majority. Lord Keith was one of the minority.
In the big paragraph on that page, which is the reference to Travers and Corvey and against Ellis, it says, as a matter of pure construction, we've little difficulty in holding the words if sued in section 3.2 means sued judgment. That is the effect of the words found liable or held liable within the meaning of the decision in George Wimpey. So the courts have certainly allowed for George Wimpey, in certain circumstances at least, in Scottish cases, and seem to have been prepared to accept that the Scottish legislation is, in some respects, going in the same direction as the George Wimpey case, though I grant that that's not exactly on the point in relation to the time concern that the court is presently asking me about. In that regard, I notice that my Lord Hope discussed the matter himself in the Cooperative Retail Services case in connection with the 1978 legislation in paragraph 58, page 103. It is only under the first part of subsection 1 and subsection 3 that exceptionally the court is asked to look at the position at an earlier date than the time when contribution is being sought. And then there is reference to, refers to liability which has been and could be established in an action. This suggests the question is not whether liability could have been established in the past, but whether it has been established or could be established as at the time when the contribution is sought. And that, as I understand it, is the lead-in to the point that the second reason that cooperative retail services the
Could you,
claim of the architects
could you
was...
possibly speak a little
Sorry, I
louder?
beg my Lord's pardon. This is leading up to the second reason why this case failed, which was that by the time the contribution was being sought, there was no right to compensation under Section 6 because it had been a right to make good and rebuild the building and correct the damage that had been wrought by the fire. And obviously the time mattered for that because there must have been a day at which, before the making good happened, that there was at least a possibility that there could be compensation. Once the making good was happened, that was no longer a possibility because what had been done was implemented the obligation under the standard form building contract on the part of the contractor to make good the damage wrought by the fire in return for payment to him of the insurance fund monies. One of the other matters canvassed yesterday was the third subsection of Section 3 of the 1940 Act. My submission is that this probably doesn't avail my Lords very greatly of much in the way of assistance. Head A of that subsection is clearly a transitional provision about providing that nothing is to affect loss or damage before the commencement of the Act. And B, I submit, is largely of the same variety. It's meant to secure that contractual rights or reliefs or indemnities are either enforceable or not enforceable according as they would have been if the section had not been enacted, i.e. that the new statutory drafting about contribution is not to alter the enforceability of contractual rights of relief or indemnity which existed as at the date of coming into force of the legislation.
Or, I presume, any other statutory right of relief which might be...
Or any other one. Or any other one. The point which I submit to my Lords is that it's addressing itself to the date at which the legislation came into force, and that neither I nor my learned friend can really plead much assistance from that subsection, as I submit. As I've indicated, however, my Lords, the matters in this case, which we've perhaps spent a great majority of the time talking about, are the ones related to the question of what flows, if it be the case, that voluntary actions of the pursuer from dates before the date of the accident are capable of affecting the rights which the defender might have to seek contribution. And on that, my Lords heard the fundamental submission which is made on this side of the bar, whether my Lords accept it or otherwise, namely that the court should be reluctant to construe subsection 3.2 so as to produce in the context of what's meant to be an equitable remedy a situation in which, though it be impractical or impossible for the defender to know anything of or do anything to protect himself against contractual rights entered into by the other two parties, nonetheless the rights of contribution he might otherwise have had may be affected. If the court is of the view that that can happen, then of course the matters relating to contract construction and about the issues relating to the frustra petis defence, the exclusion clause, the discharge that my Lords have been discussing with me for the past day and a little few hours at least over the past 2 days plainly will arise, and my Lords will dispose of them in the manners which they have tended to indicate. In that connection, I should lastly deal with one matter of, as it were, housekeeping. I mentioned yesterday in the course of discussion with my Lord Roger, I believe it was, that there was a decision of Lord Kinnear's which might be thought to bear on the frustra petis matter. I've taken the liberty of having made available from Lords, if they wish it, since it derives from Scottish Law Reporter and may be a little more difficult to obtain than some other matters might be, a copy of that for their Lordship's assistance, if they find it to be of any.
Good.
As I indicated yesterday, and as the head note of the case betrays, it's a case all about the relief of Caisheners and a situation in which the Caishener had paid his share. There are several co-Caisheners, one of whom had paid the debt and got an assignation of the debt and the bond, and the court held he wasn't entitled to seek decree against his Caisheners jointly and severally for the whole sum less his own share, but he could only get decree against each one for their individual percentages. And the passage in which my lords may be interested is one which perhaps starts halfway down the left-hand column of page 788, in which the Lord Ordinary is discussing the rule. He starts the general rule being well settled about co-Caisheners paying the debt are entitled to proportional relief from the rest, but the pursuer sues his assignee of a bond and relies on the authority of a passage in Erskine to the effect that any obligant who, upon payment, gets conveyance of the debt from the creditor is thereby in his right entitled to sue any one of the co-obligants for the whole, leaving to that one his action or relief against the others, deducting nevertheless his own share, and that of other co-obligants who are become notoriously insolvent. There is then a passage discussing whether that be right or no, and then on the right-hand column there is a paragraph which begins, "It is manifest that the right, which here arises from the nature of the joint and several obligation, cannot be enlarged by any transaction between one of the co-obligants and the common debtor to the prejudice of the others." And I don't understand the passage in Erskine as intended to indicate that it can, because he says that the shares of insolvent obligants must be deducted. But if that be so, an instant action at the instant the Caishener is paid against any one of his co-obligants in solidum can't be maintainable, for the purpose of such an action is to obtain more from the defender than his rateable share, and that must either throw upon him an undue burden in excess of his liability for relief, or else it must result, as Potier points out, in a multiplication of circuitous actions, for the co-obligant who has been compelled to pay more than his share would be entitled upon the same principle to demand an assignation for his relief, and upon that he would be in the same position as the co-obligant who had sued him, and would be entitled to recover from him, presumably the first pursuer, the excess which he'd overpaid. And then it said the whole matter is discussed in the Traité des Obligations in section 28, where Potier refutes the proposition to which Erskine has given the sanction of his authority by reasoning that appears to me to be conclusive. And that, as I would respectfully suggest, may be the passage in which my lord may have some interest for the purposes of the use, at least on the one occasion that I have been able to track down, of the objection of multiplication of circuitous actions, at least in terms rather than in Latin, as being a line of defence which is regarded as being conclusive reasoning for finding against the co-Caishener who had come with his assignation for the whole of the debt in this case. My lords, there remains the one last point, which is the question raised by my Lord Hope, my learned friend yesterday, which is the question of the disposal of the action. I've made my motion if my lords be in my favour. What if they are not? My learned friend has asked that the court restore the interlocutor of the Lord Ordinary, in which the Lord Ordinary declined to remit to probation certain averments. It may be that my lords will consider that it was apt, if they were of the view that my learned friend's appeal should succeed, that the matter should be remitted back to the Court of Session to proceed as accords, because it may be that the view might be held that the actual restrictions which have been made by the Lord Ordinary may not necessarily reflect quite the view my lords take of the case. They may be unduly vigorous or insufficiently vigorous, and it may be that my lords would consider that in such a case.
Well, if we thought that, we would probably delete or restrict the deletion.
Yes, that is another possibility that is open to the court to take. But primarily, that matter is a matter for my learned friend's motion rather than mine. My Lords, unless I can be further assistance, I suspect I've detained them long enough for the morning.
No, thank you very much. Mr. Lebekovich-Broom.
I have nothing further to add, my lord.
Yes,
My Lords, I don't feel there's anything I can usefully add to the submissions I advanced yesterday. There are no new points, it seems to me, which I need to deal with. There was some suggestion that there had been a change of ownership and that impacted on matters, but I think my learned friend eschews that as actually affecting this case
yes,
at
there's
all.
a rather interesting clause dealing with change of ownership, which seems to assume that the contract may well, in some mysterious way, remain in force, notwithstanding the change of ownership. But that, of course, will be the original contract with the original owner.
Indeed, my Lord, yes. And of course, there are the extensions here, which one sees in the bundle, all in which the present pursuers are designated as the owner, the
I think
capital.
we're missing the First Amendment or something where the change of ownership occurred.
Yeah, I think that's probably right, my Lord. But I don't think it's an issue in the case. Insofar as my learned friend's position is that the law or this court should ignore parts of the contract, as I understand it, between the pursuer and the third party, that is, those parts which would cause Section 3, subsection 2 not to be satisfied. It's really simply saying the court should remove from the picture the problematic bits of the contract for him, so that he can say, well, the section is satisfied and the right to contribution comes into play. And in my submission, there's simply nothing in the statute which would warrant that kind of approach. Effectively, the inequity which is complained of by the defenders is that they don't qualify for the right of relief in the first place. And it's really Parliament that's caused that right not to arise, rather than anything in the contract between the pursuers and the third party. So essentially, there's, unless your Lordships wish to raise any matters with me, I have nothing which I propose to add to the submissions made yesterday.
No, thank you very much, Mr. Clerk. The court is grateful to counsel for their submissions and will reserve its judgment.